In a Colorado legal debate, one of Donald Trump's lawyers acknowledged that there is subjectivity to the definition of insurrection, stating that, ultimately, we're all just making this stuff up. This information was disclosed during appeals to the Colorado Supreme Court in response to a lower court decision maintaining Trump's 14th Amendment ineligibility for another term as president. The information was reported in a Newsweek piece published on Thursday, December 7, 2023. The amendment forbids the holding of public office by anybody who, after swearing allegiance to the Constitution, engages in insurrection or rebellion. Despite the lower court's conclusion that Trump was engaged in insurrection, this ruling spurred legal discussions over whether the president is covered by the amendment. Several states have filed lawsuits aiming to remove Trump from the 14th Amendment primary ballots. Trump dismisses the Colorado lawsuit as election interference, arguing that it was started by a group of voters and that it proves his ineligibility for the presidency. Both the plaintiffs and Trump's legal team are appealing the first Denver District Court ruling rendered in November. Justice Richard Gabriel and Scott Gessler, Trump's attorney, disagreed on the concept of insurrection at the Colorado Supreme Court hearing. Justice Gabriel questioned whether it would be considered rebellion to stop the orderly transition of power, to which Gessler responded, "I'm not sure, Your Honor," adding that terms like length, geographic reach, and voiding local government power are all sort of made up at the end of the day. Under these circumstances, Gessler maintained that his understanding was shaped by the Attorney General's arguments and the historical background. Additionally, Gessler said that the events on January 6 need to be categorized as a riot, as opposed to an uprising, highlighting that the Trump supporters who assaulted Congress were not armed. Justice William Hood contested Gessler's assertion, citing the injuries to police officers on January 6 and the use of homemade weapons during the incident. The ruling by the Colorado Supreme Court may have a significant impact on how the 14th Amendment is interpreted and Trump's ability to run for president in 2024. Trump's opponent, Matt Gaetz, responded to the court hearings by posting comments on social media, expressing his views on McCarthy's resignation and its possible effects on the Republican majority in the House. The difficulties in implementing constitutional rules in the context of extraordinary occurrences are brought to light by the legal concerns pertaining to Trump's eligibility and the arbitrary interpretation of terminology such as insurrection. The final ruling by the Colorado Supreme Court might influence how the 14th Amendment is interpreted in relation to presidential eligibility. Once again, former president and Republican presidential candidate for 2024, Donald Trump, and his attorneys encountered significant obstacles in their effort to contest a gag order imposed by Justice Arthur Engoron of the New York Supreme Court. The order, which went into effect on October 3, was intended to limit Trump's remarks regarding court employees, specifically a legal clerk, due to concerns about severe threats and harassment she experienced as a result of Trump's remarks. Even after Trump's legal team broke the gag order twice and paid a total of $115,000 in penalties, they continued to maintain that the gag order is inflicting irreversible damage and would continue to do so until the trial was over. The expedited review request was made by Trump's attorneys, claiming that the law clerk's numerous contacts with Justice Engoron demonstrated prejudice. Due to the order, they were unable to publicly convey this point. Trump's lawyers pushed for a single judge to approve their request to forward their case at an unofficial meeting at the appellate court. They were told, however, that a full panel of judges would have to determine the issue in accordance with due process. It was also disclosed to the lawyers that they had missed a filing deadline that may have allowed the whole panel to review the request right away. The argument highlights Trump's position as the frontrunner for the presidency in 2024.